today, along with Ted Rollins, and we are covering two major cases across the country this hour.
We are in New Hampshire. The jury's still on the lunch break there in the case of this guy here, Adam Montgomery. The murder of Harmony Montgomery trial. Testimony set to resume in the next 10-15 minutes or so for the afternoon session. Adam Montgomery is accused of beating this little precious girl to death. His daughter. And we'll, again, get you back into the courtroom when testimony resumes.
Also in Georgia, they are on a lunch break as well in the hearing about whether or not to disqualify Fulton County District Attorney Fani Willis from the election interference case that she brought against the former president Donald Trump and co-defendants. It's underway in Atlanta, and the judge is determining if Willis financially benefited from an alleged improper romantic relationship with the special prosecutor that she picked, Nathan Wade. We're monitoring this hearing as well. We'll bring you updates throughout the day.
Let's start, though, with the Montgomery trial, and let's head to New Hampshire now. And we are joined by Court TV crime and justice correspondent Matt Johnson, who's been covering the case for us so expertly. Matt, good to see you this afternoon. Happy Friday to you. Let's start it off with what has gone down today.
Ted, Julia, good afternoon. So, wow, what another dramatic moment happening in the Adam Montgomery murder trial here in New Hampshire, where the judge, Amy Messer, cleared the courtroom of everybody in the gallery, including the media, as a witness, a hostile witness who avoided subpoena not once, but twice. She was supposed to testify last week, and then also this week. She had to be arrested and brought into court today. The judge spoke with her. She was describing her fear level, saying that her life was at risk if she were to testify. Well, we're not able to show her face, but her testimony of Nicole Giles is very important because she lived at the Fit shelter with Kayla and Adam, and she witnessed abuse of Kayla and those black eyes. Take a listen to her testimony.
Did you ever see Kayla Montgomery with bruises on her?
Yes.
Okay. Where were the bruises that you saw?
Pretty much all over her face, her abdomen, her arms, her legs.
How often did you see them on her?
Pretty often.
And pretty often, how often is that? I don't want to put words in your mouth. So
There was like a new one pretty much every day.
So just another witness talking about the abuse at the hands of Adam Montgomery, according to the state, and what these witnesses have to say. But the judge did tell the jury that her testimony, a lot of it may be considered hearsay, can be used for the credibility of Kayla, but not used as fact.
Matt, has it congealed any from the witnesses that we've heard on the stand what Adam Montgomery's theory was to people once he had Harmony in his custody and then no longer did?
Julia, you're right. So now we're hearing a lot more testimony of what happened around the disposal of the body, according to the state, and what he was telling people. Because remember, Harmony is last seen and heard of in December 2019, and that's when police say that she was murdered in the back seat of that car when she was beaten to death. And then in 2020, we're now hearing from witnesses, including Miss Giles, who took the stand, and another witness today that talked about how Adam would tell people a story that Harmony was staying with her mother, Crystal Sorey. Take a listen.
At one point, he mentioned having a daughter, but it was very quickly and brushed off.
you say very quickly and brushed off. What do you mean by brushed off?
He kind of he just changed the subject as fast as he could. He never specified a name. He had mentioned that he had 2 boys and a daughter, but he had dropped the daughter off at her mother's in Mass somewhere, and just kind of changed the subject as fast as possible.
What did he say about Harmony?
Just that he had a daughter named Harmony and that he hadn't seen her in a couple of years because her mother took her back to Massachusetts.
And again, as I mentioned, Crystal Sorey, her mother, was in court today. Another tough day to listen to all of the lies and what happened to her daughter. She's not doing any interviews right now. She just really doesn't want to jeopardize the case. We get it. But she says that she appreciates all the prayers. And today she was actually wearing pink earrings that she got for Valentine's Day. She said that they are Harmony's birthstone, and she was wearing them for her today.
God, it has to be horrible for the mother, Crystal Sorey, because of the details of what happened to her daughter. Matt, talk about the U-Haul. That was brought up again today.
That's how the day started, Ted. So we heard from yet another witness, one of 3 that testified so far. Today, we heard from Mr. Travis Beach himself, and he was talking about how he rented Adam Montgomery the U-Haul van and put it in a different name. And remember, there was already testimony that his girlfriend had rented them a motel room. And this is all around when Kayla Montgomery says that Adam removed the remains of Harmony and got rid of them for good. Take a listen.
When he contacted you and asked you to rent him a U-Haul, what did you do?
I didn't hesitate. He's a friend. I wasn't thinking of anything negative. I was at his apartment. I saw everything packed up. I put 1 and 1 together, thought it was 2, but it wasn't.
What did you do when you returned to the Econo Lodge?
We did drugs at the Econo Lodge.
When you say we did drugs,
Yes,
who's
sir.
the we that you're referring to?
Myself, Brittany Bedard, Adam, and Kayla Montgomery.
And what drugs are you referring to? What kind of drugs?
Cocaine.
Is that crack cocaine?
Yes, sir. Adam Montgomery and myself went outside to smoke a cigarette. He was pacing back and forth. He said he effed up, and I asked him what he meant, and all he could say and repeat was he effed up.
So the state is really pointing out to this jury that Adam wanted no record of ever renting a U-Haul van, ever renting a motel. So then Travis Beach is on the stand and testifying to the fact that he followed up with Adam, making sure that he returned the vehicle to U-Haul. And Adam replied to him via Facebook very strongly saying, "Don't ever message me stuff like this on Facebook again." Really trying to cover his tracks, according to the state.
Matt Johnson, thank you for those powerful moments inside of the courtroom today. And for that recap, let's bring in our guest, National Trial Attorney Michael Jaafar, who is standing by to discuss. Michael, the prosecution had on their list, their witness list, about 50 to 55 witnesses. They're on witness number 35 is about where they are. Your thoughts on how much longer they need to go to prove their case, to carry their burden?
I think they're in the boa constrictor mode at this point. They're just squeezing the life out of the defense. I think if they stopped right now, they'd have enough to basically cook this guy. But they'll probably just go for the rest, right? I mean, for all we know, they're training young junior prosecutors and showing them the ropes. I mean, I've seen prosecution departments, when the cameras are on and they're in the courtroom, prosecutors they extend a case longer because they don't want to take the chance of ever screwing up or anyone ever questioning, hey, why did you stop at witness 30? Why not go to witness 45? You had them, they could have helped. And also juries are very unpredictable, right? And so you just don't know, right? At this point, if they had a crystal ball and they saw that a jury was going to convict them for second-degree murder, they would stop right now. They would have stopped yesterday, but they don't have that crystal ball. And so to answer your question, Julia, I don't know. Maybe they'll run the table. They are in boa constrictor mode, so they are squeezing the life out of the defense. They might go another day or two.
I have a crystal ball, and they will convict him of, yes, second-degree murder. For sure. I mean, I think this is overkill, but to your point, they want to, they've worked very hard on it, and they had to do it in a unique way on the back end after the ball was dropped by different people over the years, yeah, and individuals close to Harmony as well. What about Adam Montgomery's defense? We heard in the opening statement, Michael, oh, he's going to, he only helped deal with Harmony's body, but it was Kayla that knows what really happened. She's a liar. Was the cross-examination of Kayla enough to stand up with a straight face in closing arguments and still continue down that road, or do they have to bring him in?
They're going to have to bring in evidence. The cross-examination of her just basically broke down her credibility. She was caught on some, I mean, she even admitted to, forget if it was not perjury, but lying to investigators. So they're going to have to bring in more in order for them to prove their case in chief, because when they made their oral argument, their opening statement, they made promises to the jury. So they've created a situation where there could be a credibility deficit if, in their case, they do not connect the dots that they said they would connect. Because if they don't do, and they are going to do that, obviously. They obviously have a bunch of things that they want to do in their strategy. And then in their closing argument, they can then connect the dots and earn the credibility with the jury. But with that being said, I mean, even the prosecution's case, technically, if you're a robot and you step back and look at it, technically there's no evidence. There's a lot of circumstantial evidence of what he did after the fact. There's technically no evidence that he met the elements of second-degree murder. Abusing a corpse, easy, done. But I think because human beings are on the jury and they see the level of neglect and the level of covering up what happened, I just don't see human beings in the jury acquitting him no matter what the defense does. Now, I've said that before and I've been surprised, but we'll see.
We will see, and we have seen husband and wives who have been accused of killing a child. Even if just one of them did it, they both go down for first-degree murder. So who knows what the jury will do, knowing that Kayla has already been serving time. Michael Jaafar, stand by. We have testimony that's resuming at any moment in the Adam Montgomery trial. We're going to squeeze in a break and have more on the other side.
All right, we want to head to Ohio. Earlier today in the Jason Meade cases, the sheriff's deputy, the judge came out, declared a mistrial because of a jury question. Then he changed his mind. About an hour later, they started deliberating again. They now have another question. Let's go in and watch.
I've received a question that says we are currently hung and unable to reach a unanimous decision on any of the 3 charges. In a large portion of cases, absolute certainty cannot be obtained or expected. Although the verdicts must reflect the verdict of each individual juror and not mere acquiescence in the conclusion of other jurors, each question submitted to you should be examined with proper regard and deference to the opinions of others. It is desirable that the case be decided. You are selected in the same manner from the same source as any future jury would be. There is no reason to believe that the case will ever be submitted to a more capable, impartial, and intelligent than this one. Likewise, there is no reason to believe that more or clearer evidence will be produced by either side. It is your duty to decide the case if you can. Conscientiously do so. You should listen to one another's opinions with a disposition to be persuaded. Do not hesitate to re-examine your views or change your position if you are convinced it is erroneous. If there is a disagreement, all jurors should re-examine their positions, given that a unanimous verdict has not been reached. Jurors for acquittal should consider whether their doubt is reasonable, considering that it is not shared by others, equally honest who have heard the same evidence with the same desire to arrive at the truth and under the same oath. Likewise, jurors for conviction should ask themselves whether they might not reasonably doubt the correctness of the judgment not concurred in by other jurors. You can go back and deliberate.
All right, so it continues up in Ohio.
Sent them back in, read the Allen charge, and then just said, go back, deliberate. Essentially doesn't care if they've not been able to reach a verdict.
And especially after they were kind of given the old "you're done" speech earlier. Let's see if he says anything here outside the presence of the jury. Nope. Heading back to Chambers. Michael Jaafar. So I don't know if you saw it earlier, Michael. This morning, the jury had a question. Judge came out and said, listen, guys, you worked hard. I'm declaring a mistrial. Goes back to his chambers, figures out, now I bring them back, sends them back to start deliberating. Now, a couple hours after that, they say, hey, sorry, Judge, we just can't do it. And he gives them the old Allen charge.
Now gives them the Allen charge, not back when he sent them back to redeliberate.
Your thoughts?
yesterday, there was a question by this jury, and they asked to see the written statement by the police officer, right? And so when we were debating it on TV, the question was, why would they ask for it when it was read into evidence already, but it wasn't given to them when they went back into the box? It was just merely part of the evidence, and the judge didn't make it part of the evidence, but they asked to see it. And what I said was, I think there were two juries in there locking horns. We had no idea that they were trending to a mistrial yesterday. I said, I think there were two jurors in there, one adamant for an acquittal, one adamant for a conviction, and they were both debating on what they remember the statement said, and they couldn't agree, and so they said, you know what, let's see it, and let's see which one of us is right. And then now what it seems like is that little tension between them went into today, obviously, and they're locking horns. I think we're going to end up with a mistrial here. I know they're still deliberating, but whenever you see jurors asking to see evidence that was already admitted into evidence, usually it's because at least one or two of the members of the jury pool do not agree and are locking horns, and they want clarification. And sometimes, you know, human beings, they can't see eye to eye all the time. It's very difficult to get 12 people in line on anything, even where to go to dinner. But yeah, I think Ted, this is trending towards a mistrial.
And Michael Jaafar, you're talking about those different members. There have been some strange things that have happened during these deliberations. We heard a question from the jury yesterday after the one you mentioned where they said, can we be hung on one count and not on the other? They were sent back in to deliberate after that and said, don't tell us what the counts are, but if you're deadlocked, let us know. And then we saw some jurors removed, and court officials haven't confirmed why they were removed and replaced with alternates. But do you think all of these issues, including this kind of false start mistrial, could that be an issue on appeal if there's a guilty verdict?
Absolutely, absolutely, absolutely. What the conduct of a jury obviously is always part of it, right? I mean, it's the jury system, right? So, so absolutely, and you know, kudos to the defense attorneys obviously for not waiving the jury in this case. Anytime you have a police officer on trial for anything, your luck is always better with the jury, and you see why, right? Because it's going to be very difficult to get 12 people of your peers, agree that there was misconduct. So I absolutely agree that's a part of it, and that could be a big part on appeal. I mean, this has appealable error all over it if he's convicted now after what we've seen. Can you imagine being convicted now after having an acquittal or walking out dangled in front of you? I mean, that would be something.
Mm-hmm. We'll see what happens. They're back at it. Let's do this. Let's go back now to New Hampshire, pick up our coverage of the Montgomery case. Detective Adam Bergeron, Rosa on the stand.
Why did you want Walmart?
To see who possibly Kelsey was with when these transactions were conducted.
What steps did you take to obtain that footage?
I contacted the asset protection officer at Walmart, Mike Doby, and requested the surveillance video footage.
And did you obtain it?
I did.
And I think you mentioned this, but you interacted with Michael Dope?
I did.
And similar to the cell phone that we just discussed, did you give that footage a specific evidence number?
I did, and that evidence number is ABR2.
Thank you. Dr. Bob, no further questions for you.
Good afternoon. I have no questions.
Okay.
May I step down?
Thank you.
Thank you. Your Honor, at this time, the state will call Detective Lou Krozik to the stand, please. Good afternoon, Detective. Please, go right up to where the bailiff is. Watch your step on the cords, please, on the way up. Thank you, sir. And Detective, you would remain standing just for a brief moment. You solemnly swear the testimony that you will give this jury will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you, sir. Please feel free to have a seat. And Detective Krozik, as we're being recorded here today, please state your full name and spell both your first and your last name for the record.
Louis Krozik, Louiskraczczyk.
And as we can probably guess from your title, can I ask you where you're currently employed?
Manchester Police Department.
How long have you been working there?
About 23 years.
About 23 years?
Yes.
Okay. Did you graduate from the New Hampshire Police Standards and Training Academy?
Yes.
And do you remember your academy class number?
131.
131. With regards to the time that you've been working at the Manchester Police Department, can you describe for us, please, a couple of the different positions that you've had and the different sorts of duties you've had during that time?
I started as a dispatcher. In 2003, I became a police officer, and I worked patrol for about 12 years. I then became a detective, worked general cases, investigations, and moved to cyber crimes in, I think, 2017.
2017. And are you still working cyber crimes to this day?
Yes.
And working in that particular unit or division, how are those duties different from necessarily other detectives that might be working juvenile crimes or domestic violence crimes or general adult crimes?
I mostly work with evidence for other cases that other detectives do.
All right, as he goes through his background, a good time to slip in a commercial break as we approach the top of the hour as well. Enjoy your weekend.
Have a good weekend, Ted. We have much more ahead. Don't go anywhere. The Montgomery trial continues after this.